ask you two kind of semi-related questions. So, what are mistakes that you see by inexperienced attorneys that are not familiar with ERISA? What do you commonly see?
You don't dabble in ERISA. You don't ever dabble in ERISA. You're either in or you're not. And that's by far the most common thing, because people don't understand that ERISA is very, very logical when you do it. I mean, it's one of the things that I love about it is that, I've been doing it for so long that I've seen all the angles, and there's nothing new that's coming in. In 40 years, I've seen stuff come and go 5 and 6 times. I mean, that's how often those kinds of things happen. VEBA is a perfect example, a voluntary employee benefit association. It's a way of doing a self-insured health plan for people. And I've seen it come and go in popularity 6 times at least during my 40 years. And it's just because things are there and there is a logic to it, but you don't always get it right away. When you first pick these things up, you think they ought to be this way, but they're not necessarily that way. It's very similar to labor law in California. Labor law in California is not always intuitive, where you just know off the top of your head, well, that makes rational sense. We'd probably do it that way. There's rules, and the rules say you got to do it this way, and here's why. And so that's really how ERISA is. And you see people dabbling in it. It's dangerous business.